Hey, everybody. Thank you for everybody who has joined us a little bit early here. We're going to be getting everything rolling here in just a moment. I'm getting my screen share set up. We're letting everybody get their audio set up. And I see a bunch of people still rolling into the session here. If you are on and you've been on here early, and you could just maybe use one of the little reaction emojis there on your screen, that'll give me a heads up that you can hear me. So maybe just give us a thumbs up in the chat. Oh, there we go. Some hand raises, some claps. Awesome. Thank you all so much. I've been seeing a bunch of people in the chat already pretty early here. We've got some people in the Pacific Northwest. We've got some Canadians. We've got some New Yorkers, Ohio, North Carolina, Maryland, Washington. So we got people all over the country, New Hampshire, Maryland. There we go. So we thank you all very, very much for joining. Today, our session is going to be what you need for HIPAA compliance in your practice, proper tools, policies, and training. I'm going to go through introductions and a basic agenda for the session in just a second. But two housekeeping items that I like to cover before we get super deep into the content here. One of those is all of our webinars are recorded. You will get the recording sent to you, usually within 24 to 48 hours of the end of the webinar today. We can also send you copies of the slides with that if you would like to have those. So just keep an eye out on your email. You should see that come through at the end of the session today. The other thing I'll say, and let me make this full screen here. The other thing I'll say is, in addition to all of the webinars being recorded, like many of you who are already engaging here in the chat, we love to get questions on these webinars. Chances are is we will not be able to get to every question. We've got potentially over 1,000 people joining us today, so we may not be able to get to every question that is asked. What I would say is, because sometimes things get lost in the chat, if you have a question, please specifically make sure that you go to that Q&A segment and submit your questions in there. That'll also allow other people to see. People can even upvote questions that are submitted. So if somebody else asks a question and you have the same one, you can upvote it so we all see it. And with that said, yeah, we're going to be diving in here and going through some of the content. Some quick introductions. My name is Liam. I'm our Director of Solution Engineering here at Compliancy Group. I've been here for about 8 years now, and my kind of main specialty in terms of healthcare compliance has always been HIPAA compliance. That's probably my area of biggest proficiency, and that happens to be what we're speaking about at length today. I am joined by Lauren Vetter, who I'm very excited to have Lauren today, because Lauren is the head of growth for OptiMantra, who is a partner of Compliancy Group. But I think Lauren was going to say this. I'm going to spoil it for her. Lauren is also actually a former Compliancy Group employee. One of my favorite people I've ever worked with. I mean that. So super excited to have her here with us. She has a lot of experience, not only from her time here as it concerns compliance, but also helping small practices with the right types of technology solutions to operate in a way that's compliant. So Lauren, if you wanted to just take a second and introduce yourself, that would be great.
Yeah, I think you covered a lot. So I'm Lauren, head of growth here at OptiMantra. Been here since February of this year, so coming up on a year. Prior to that, I spent around 5 years at Compliancy Group. So in total, I'm around 7 years in the healthcare tech space. I'll echo Liam's nice sentiments. Liam's incredible. I'm so happy that we have a topic that we can speak on together, and looking forward to a great session here.
Brilliant. And thank you to all of you for joining. I know that taking time out of your day to listen and learn about HIPAA compliance is maybe not the bright shining star at the top of your day for most people talking about compliance. So we appreciate you coming in here. I'm going to give a rough agenda of what we're going to be covering. I'm probably going to be starting out the session today covering some, call it HIPAA fundamentals. Like, how do I know if I need to be HIPAA compliant? What does it mean to be HIPAA compliant? What are maybe some of the key things that you should be considering as a practice when it comes to your compliance program? where they're going to be moving into more of a focus on HIPAA compliance and technology within your practice, how you should be looking at the tools that you're using within your practice, what some of the common pitfalls are, and ways that you can also protect your business. Before we go into the fundamentals, I wanted to take a second and just launch a few polls here to the audience. So you'll see this pop up on your screen here now. First question is actually just how familiar are you with these requirements and how they apply to your practice? Maybe a lot of you are coming in and you've been doing this for a long time, you're super familiar. Maybe for others of you, you're somewhat familiar, you've been dipping your toe in the water, so to speak. Others of you maybe are starting from scratch and are just not very familiar at all when it comes to the HIPAA requirements at all. Looks like we have a good mix here actually between people that are very familiar and somewhat familiar. So that's nice to see. Thank you all for participating in the poll. That just helps us. I think like my intention for today is to hopefully give those of you that are very familiar, maybe a nice refresher on some fundamentals, but also some advanced strategies that you could bring back to your practice. For those of you that are starting from a clean slate though, our goal is like square one. What are the things that you should be doing within your practice today for those of you that are really, really fresh to this? So you'll see us talking through all of those topics as we go through today. I'm going to launch one or two more questions here. One of them is, when did you complete your last HIPAA risk assessment? This is an important one. It's part of what we'll be talking about as part of the fundamentals, but maybe you haven't done a risk assessment before, you're not sure, maybe you've used the software in the past, maybe you're just doing this very manually right now on a spreadsheet. Understanding your familiarity with this topic particularly, I think is really, really essential. So for those of you that are in that, like, I'm not sure, or I don't think I've done one, we're going to be talking about this particularly quite a bit today. You'll see me mention this topic a lot. I'm going to keep bringing it up. So like for those of you that are in that, I don't think I've done one before, that's going to be one of my main takeaways for you. I'm just prepping you in advance for that. So get ready for us to talk about that quite a bit. Okay. I'm going to go ahead and bring this down. Last one is going to be, as it concerns patient communication, how confident are you that your patient communication is HIPAA compliant, meaning the tools that you're using? And that could be any number of things, like the software tools you have, your email services, anything like that, right? It's kind of like all of the above, just looking to get an idea as far as how comfortable everybody on the session today is, and seems like 50-50 between like somewhat not at all and very confident. And for those of you that are in that very confident zone, our goal today is to maybe actually talk about some new technologies, particularly AI, and how that might influence how you operate in the practice. So our goal for those very confident folks is that you come away from this session with some great tips. If you're only somewhat confident or not at all, we want to, again, from a clean slate, what should you be thinking about as you get off the webinar today and you're going back to your practice? Want to make sure that just as clear as possible. So thank you all for participating in that. We are going to go ahead and get into the content now, starting out with some HIPAA fundamentals. So let's dive in. So HIPAA fundamentals, every practice must understand. I speak with tons of people where they are coming to a webinar like this because they actually don't know if they need to be HIPAA compliant at all to begin with. So I like to talk about this topic a little bit, and you'll see two definitions here on your screen, one for what's called a covered entity under HIPAA, which is anybody that, like, let's say you are a medical practice. That's what most people commonly think of as being a covered entity: healthcare providers, clearinghouses, insurance providers. But I'm going to give a little bit of insight into this definition of a covered entity, which is that HIPAA literally stands for the Health Insurance Portability and Accountability Act. So when you're thinking about your practice's situation, even if you're providing medical services, if you are a 100% exclusively only cash pay practice, you are not actually considered to be a covered entity. And so for some of you, that might be like cause for celebrations right now on your end, because you maybe don't need to be thinking about much of these things. What I would say though is that even if you are a cash pay practice, practices as it concerns privacy and security, you still really want to consider these things. HIPAA, when you are a covered entity, it actually gives you some extra protections from a liability perspective. If you're a covered entity under HIPAA, your patients can't actually directly sue you for privacy or security violations. It has to all be routed through the regulators. So it actually gives you some extra protections where if you're a cash pay practice, it might actually be just as important for you to be thinking through these things, even though you're not technically covered under the HIPAA regs. So just a few things worth keeping in mind there. Second thing is going to be what a business associate. And so maybe we have some folks on here that are business associates. The simplest way of thinking about a BA is that they're a healthcare vendor, right? They are supplying and providing services to a covered entity that involves either the access, the storage, or the exchange of PHI or protected health information, meaning any patient data of any kind, really. Okay. Requirements as it concerns BAs are very, very similar actually to the HIPAA requirements for covered entities. It's just because they're not actually treating patients, the applications of these rules look a little bit different for a BA or a CE. So hopefully for some of you, just those basic definitions gives you some clarification here. Again, if you are not billing insurance, you might not be considered a formal covered entity, but it doesn't mean that you shouldn't take your patient's privacy and security seriously. It just means that maybe you don't need as much documentation as a formal covered entity would, right? So with that out of the way, what does it actually mean to be HIPAA compliant, right? And I'm gonna change the screen option here so you could see the bottom of the slide. In order to be HIPAA compliant through HHS and the OIG, their definition is that you need to have an effective compliance program. These 7 elements that you see here on the screen is what HHS defines as being the core boilerplate requirements and components of a compliance program. I like to show this just quickly, not to really go through each one of these elements right now. We're going to talk about this as we go through the session today. But I do want to just really draw your attention to that word effective. Okay. HIPAA is a very intentionally vague regulation because of how broadly it applies. You could be a solo provider practice that's a covered entity, or you could be the largest regional hospital system in the country, and the rules don't change. The reg is exactly the same regardless of how large or how small you are. What the government expects is not that you're doing less than what the law requires, but rather that you're understanding these requirements and implementing them into your practice in a way that is effective for you, okay? Biggest way that we recommend our practices to begin that process of, well, what does that mean for me? What actually is effective for me in my practice is to think about the requirements as it concerns HIPAA risk assessment. This is the first time I'm talking about risk assessment so far in this webinar. There will be more, I promise you. But we talk about it so much because when you look at what practices actually get in trouble for, if you ever had a breach or if you were ever audited, 4 out of 5 of those cases, 80% of all of the HIPAA fines that have ever been levied cited missing risk assessment documentation as the key reason for the fine. You can mitigate most of your risk from a HIPAA perspective by just doing the required risk assessment, okay? Because that's how you kind of figure things out, right? If you're going back to that previous slide and you're saying, well, I don't know what policies I need. I don't know what trainings I need. I don't know what I should be doing when things go wrong. Your risk assessment will actually help you identify all of those potential needs, because it's basically the process of reviewing the regs and documenting how you're satisfying them. There are free government resources to do this. You could literally Google free HIPAA risk assessment to get a basis for yourself. It's something that we offer as well. I'll talk about that later. But for any practice, this is where I recommend that you begin. If you're one of those people who is like, I've never done a HIPAA risk assessment before, or I'm only somewhat familiar with the regs, this is what you want to be looking into when you get off the session today. Because if you're not doing this, we're going to go through some real world case studies a little bit later. It's almost guaranteed that you would not pass an audit if you don't have this documentation in place within the practice. So gonna make that my most firm recommendation for those of you that are on here looking for some basic fundamentals. Look into this, have that be one of your key takeaways as you're coming out of the session today. So here, I actually want to now tee up Lauren to talk through some topics as it concerns HIPAA compliance and technology specifically. So Lauren, I'll let you take it away here.
Yeah, and great foundation there, and good emphasis on the risk assessments. So as we talk about HIPAA in 2025, it's nearly impossible to separate compliance from technology because your patients are expecting that digital first experience. So we have here some industry stats. So 62% of patients want to communicate with their provider via email. 64% are scheduling appointments online. 61% say digital services influence which physician they choose, and 2/3 would actually switch providers solely to access their records online. So the demand is super clear that patients want convenience, they want transparency, and they want easy access. But with every one of these digital touchpoints comes with a different compliance responsibility, which we'll go into on the next few slides. So emailing patients, offering online scheduling, giving access to those records. They require the right HIPAA safeguards in your systems. They require them in your workflows and then also within your tech stack. So as we look at compliance and patient communication, it's easy to hop right into the policies and risk assessments, but this is where we see a lot of providers unintentionally slip. So they want to reach you in multiple ways and multiple channels. So your portal, two-way texting, direct mail, but they all have those compliance considerations. So patient portal messaging, it's always the safest because it's built for HIPAA. What we found is a lot of patients choose to not use that and do prefer other methods. So if you're looking at two-way texting, which is what we see a lot of patients prefer, you need to make sure it's done through a secure, compliant platform. So no personal cell phones and no unencrypted tools. Email, still one of the most common communication channels, but you need the right consent and the right protections in place if you're going to use that. And then direct mail, which seems really simple, can actually cause a lot of issues if the sensitive information is visible or if it's sent incorrectly. So make sure that if you are sending out direct mail that you're limiting PHI to only what's needed for the mailing purposes. Some physical safeguards that you can put into place would be using secure facilities and restricting access during production. Take a look at your envelope design, so prevent PHI visibility through windows or on the exterior of that mail piece. So make sure that you're matching your workflows and your tech to how the patients already communicate. Make sure you're making it easy for them and accessible for them, but also protecting your practice there. And then staying compliant with telehealth regulations. So this is a big one, and we've broken it down into essential requirements and then what we recommend as best practices. So on the essential piece, the technology security is of the utmost importance. So using HIPAA-compliant video platforms with end-to-end encryptions and signed business associate agreements, those BAAs. Consumer platforms like FaceTime, Skype, or standard Zoom accounts without BAAs are not sufficient for routine use, and we don't recommend you use them. Under patient consent and documentation, you need to obtain informed consent specifically for telehealth services, documenting the modalities used, your privacy limitations, and any potential risks. And this should be separate actually from your general treatment consent. And then for access controls, make sure you're implementing really strong authentication measures, including unique user credentials, automatic session timeouts, and role-based access permissions. Never share your login credentials among your staff members. That's super important. On the best practice side, environmental privacy. So make sure you're conducting your telehealth sessions in private locations on both the provider and the patient ends. Use visual backgrounds when appropriate and ensure that your conversations can't be overheard by any unauthorized individuals. For data transmission and storage, make sure that all your patient data is transmitted during telehealth encounters and it's encrypted in transit and at rest. Maintain audit logs of all access to EPHI. On the training and policy side, provide regular staff training on telehealth specific privacy policies that you've outlined. Maintain written policies covering emergency protocols, technical failures, and breach response protocols. And then on the state license side, just remember that HIPAA is just one piece of the puzzle here. So verify that your providers are actually licensed in the state where the patient is located during that telehealth session.
Yeah, and folks, I think one of the key things here that Lauren covered is the business associate agreement piece. I think for a lot of the practices that I speak to, they think through, well, there's all of these technical requirements that I know need to be implemented on the system. If you're not very tech savvy and you don't know what types of questions you should be asking, the simplest litmus test for most of these vendors that you could be working with is whether or not they are willing to sign a BAA with you. Because if the answer is no, and as an example, like what Lauren mentioned, Zoom, Skype, FaceTime, there's no way of getting a BAA with any of those companies. Zoom will do it, but it's an unbelievable amount of money that you need to pay to actually make that happen with them. So if you don't have a BAA, treat it as unsafe as far as patient communication is concerned. And then even if they sign a BAA, that's when you could really start to look into, well, what are the specific technical requirements that I should be satisfying within these platforms in addition to that, okay? Now, part of, I think then where this goes into is some of where your liabilities actually lie. And one of the biggest misunderstandings that we see is practices that think, well, I have, and you might be in this position where you have compliance technology, you have your BAAs in place, but here's sometimes one of the challenges is you could have a compliant platform, but if you're not configuring it, but most importantly, using it in a HIPAA compliant way, that is where you can often get into some problems, right? So as an example, if I have a platform that I'm using in the practice and it never touches patient's information and I never have patient information there, I'm using it in a way that's compliant, right? Even though I don't technically have the right controls in place, by not having any patient information there, I'm using it in a way that's compliant. If you have platforms that you have a BAA or where you have documented all of those steps, as an example, two-way texting, you can use a two-way texting platform and mistakenly message something that was intended for another patient to the wrong person, right? So those human error components still come into play, where it's as much about your people as it is about the technology in and of itself. And so that's where, like, we want you to really understand the two sides of that coin. Now, your responsibility on your end is, number one, as part of the risk assessment, is to make sure that you're satisfying those requirements for things like encryption, access, making sure that you're handling incidents as they occur. But then you having the right policies, procedures, and training within your practice is how you illustrate your efforts in the eyes of the government, right? Because if you're not showcasing that stuff, showing that, hey, we not only have compliance technology, but we have procedures in place that our employees are following, and we're training our staff on best practices for how to use these tools in a way that's compliant, combined with other things that you might have in place, like cloud services that are encrypted and compliance and all of that stuff. Everything as it concerns compliance specifically is about your ability to show proof of your efforts, right? It doesn't, I hate to say it this way, but it really doesn't matter what you're doing in practice. What matters is what you are able to prove on paper, because that's what the government would ask you for. So I don't want you to think of these things as we're talking about this as like, oh, I'm doing that. What if you got a letter in the mail and the government was asking you for your documentation of that thing? How would you show that to them? That's how you want to be thinking about this. So that's where like a lot of that liability piece comes in. And with that, I don't want to just say all of those things. I want to give some real world examples of where these things go sideways. And there can sometimes be a lot of fear as it concerns topics like HIPAA, but I want to be clear here. So you'll see there are 6 examples of fines that were levied to relatively small organizations over, I think most of these are relatively recent as of the last couple of years, okay? In all of these cases, there was something wrong that was done. Something bad happened. Security guard caught snooping into medical records. Bad, right? Responding to a negative online review and exposing patient information. That's bad. Ransomware incident, a major breach, failure to provide medical records, sharing patient success stories without their permission, right? All of these things, there was something wrong that was done. Patient privacy was compromised. But when you look at what these companies were actually fined for, in most of these cases, the fine was not levied because somebody made a mistake. The fine was levied because they couldn't prove that they had some component of an effective compliance program, meaning those security guards were caught snooping into medical records, but Yakima Valley couldn't prove that they had the right policies and procedures in place that would have governed and prohibited that behavior. Same thing with Manasseh, same thing with Cadia. In these other 2 examples here, there was a breach and a ransomware incident, but when they were audited, they couldn't prove that they had done that required risk assessment of HIPAA. 3rd time I'm talking about that, if you're keeping notes, right? Actually, 100% of the fines that have been levied so far this year cited missing risk assessment documentation, okay? So all of these things kind of come into play, but even just like what you're looking on the screen, do you have clear and effective policies? And when I say effective policies, that is ideally not a binder that sits in the back of somebody's office and collects an edge of dust over a couple of years, right? True policies and procedures that govern how your practice operates, that your employees are using and attesting to. Are you training your employees, and do you have proof of that? Have you completed that risk assessment? All of these things come into play here. Okay. Lauren, interested with kind of the next couple of slides here, getting some insight from you on AI best practices as it concerns technology specifically.
Yeah, and that's a question we have a lot. Can I use AI in my practice? And the answer is always yes, with a big asterisk and an underline there. So you can. You have to use it responsibly, and you have to use it in a way that is supporting rather than replacing your current compliance program. So we have some do's here, and I'll go into some don'ts in a moment, but you can treat AI as a drafting helper, but not as an authority on your content. So it can certainly help you brainstorm, organize your ideas, summarize non-PHI documents, but it should never be obviously the final decision maker. Keep PHI out of AI tools unless you have assigned BAA. I mean, that will be the big takeaway here. Do not put any PHI into any AI tools. Even small patient identifiable details can be considered a HIPAA violation. Always validate that AI generated content against your authoritative standards, meaning your HIPAA requirements, your OSHA guidelines, state rules, dental board guidelines, whatever applies to your practice there.
And that means, everybody, do not be chatting with ChatGPT about your patients and your conversations with them, okay? Mm-hmm. That is a big, big no-no, all right? Want to be really, really clear about that. I think that's one of the most important things that Lauren has said on this slide. I have come across many practices where they've found their employees, and keep in mind, it might not be you on this webinar. You could have employees that are doing this on their cell phones or on their desktops. Bad, bad, bad. Don't let that happen.
Yeah, I think a common example we see is people are copying maybe difficult emails from patients and putting them into ChatGPT and asking for some guidance on how to respond. Do not do that. Do not ask it for help on specific patient feedback. Just use it with extreme caution, a brainstorming tool, and do not put any PHI into it. You can use it to streamline those internal low-risk tasks. So brainstorming language for your website, drafting your frameworks, summarizing any of your content that doesn't contain that PHI. I'll say that over and over. That will be my risk assessment takeaway. You can use it to document your review process. So you can let it help you draft a policy or procedure. But note that that reviewing step that you take will strengthen your compliance posture and demonstrate your thoughtful oversight. There's great ways to use it and it'll help you save time. But just be super, super cautious. This is a new way where people are getting a little caught up in. And then going into the don'ts, we already know some big don'ts, but do not copy and paste ChatGPT policies into your compliance program. They are typically generic, they're often outdated, and they're very rarely aligned with your state, specialty, and operational requirements. So this might give you a very false sense of security, and in an audit, that can actually increase your risk. Along those same lines there, don't assume that AI understands your state-specific rules. They sound very confident, even when they're completely wrong or they're missing critical requirements. So that's why legal, regulatory, or risk assessment decisions should never, ever be delegated to one of these AI tools. Another area of risk I want to call out is it should not be creating required documentation without expert review. So that's your risk assessments. Again, your incident reports, your BAAs. These are documents that the OCR is going to scrutinize closely. Any incorrect or incomplete versions would be a major red flag. So make sure that you're reviewing those. Your legal team is, any of your compliance officers. Don't trust AI to take a look at those. And then, of course, I'm going to beat this over the head. Do not enter PHI, your staff names, details on any incidents that you've had, or any internal risk data into these AI tools. Without a BAA in place, it will count as an unauthorized disclosure under HIPAA, which is a major no-no. And finally, it comes back to what we've said before on staffing and training. Don't let your staff use AI unsupervised or without clear documented internal guidelines. You need documented boundaries around what your staff can actually use AI for, especially if it's anything related to patient communication or compliance. And I'll kind of go back to what Liam just showed with some of those violations. If your staff is incorrectly using AI, but you had those policies in place and you train them, you won't be at fault. But had you not have any of that documented, your practice will take the brunt of that mistake. I think just the bottom line here is that AI is super powerful. It can absolutely help you save time, but it has a lot of responsibility tied to it. And just to really document your internal policies when it comes to using AI in your practice.
Good stuff. Yeah.
Going back to that AI templates piece too, one of the biggest misconceptions that we've come across is that you could take your very generic AI template, drop your practice name into it, make some minor tweaks, and kind of just call it a day. But that approach really takes some significant risk upon your practice. So these templates almost always miss required elements, whether that's a HIPAA provision, an OSHA requirement, or a state-specific rule. Secondly, they don't reflect your actual workflows because they shouldn't know them. So regulators expect your policies to describe what you do, not what a generic clinic might be doing. Thirdly, AI tools frequently suggest requirements that don't actually apply to you, or they skip the ones that do apply to you. That's going to lead to gaps, inconsistencies, and contradictions across all of your policies and procedures. And then finally, this fourth point here is that regulators are super clear that compliance documents must be customized and practice specific. So policies that read like very generic AI templates are going to be a red flag in an OCR audit. The goal here is not to scare anybody or eliminate AI from your practice entirely. It's just to make sure that you're using it responsibly. Use it to help you brainstorm or organize, but your final policies need to be reviewed by experts and tailored to how your practice is actually going to be operating.
Yeah, I think that the ChatGPT policies and generating legal content, the thing that I'll say here for everybody is that you may have heard the term AI hallucinations. It actually, some of the newer models, it happens much less frequently, but literally just like a week ago, ChatGPT was having a hallucination as I was dialoguing with it and insisting to me that Joe Biden was still the president of the United States and that Donald Trump was not the current president. So AI makes mistakes. It can commonly have hallucinations where it considers things that are not real to be real. So again, be very cautious with using it for any legal or regulatory content or advice. Something that we recommend just being cautious with.
Mhm.
Now, in this next segment, wanted you to give some insight, Lauren, specifically as it concerns EMRs and how to vet these platforms out, and maybe a few other items here we'll cover.
Yeah, so there's a handful of things that you really should be looking at when you're vetting your EMR platform. You want to make sure that it meets the security and privacy standards that your practice in particular is responsible for. Not all systems are created equal, and so there's a few areas we've outlined that you should be looking at closely. First, let's check for the basics. So secure online appointment booking. The patients, like we talked about earlier, they're expecting to be able to do that, but it needs to be encrypted and properly configured. Role-based access controls, make sure they have the capability so that staff can only see the information that's appropriate and pertinent to their job. Audit logs and activity tracking, that's essential for monitoring access and catching any issues early. Two-factor authentication, which is a must-have in 2025 for protecting those accounts. Let's look at how your EMR handles timeouts, those access controls, your patient communications, which we've already touched upon, tools that allow texting, emailing, portal messaging. They need to be built with HIPAA requirements in mind, not just as a convenient add-on. And then number one point there is don't overlook your cybersecurity insurance requirements. So many carriers have minimum technical standards that systems need to meet. If your EMR falls short, your coverage or your claims could be at risk. So it's always a good idea to just check in and make sure that your EMR has some form of cybersecurity insurance. You're choosing a security partner really when you're choosing your EMR. So make sure that your partner is equipped to protect your patients and to protect your practice.
Yeah, and I'll chime in. So for those of you, like we talked before about making sure that you have a BAA in place, when you're ready to do that deeper evaluation, this would be the slide I recommend you to go back to, right? So the secure booking, the access controls, the multi-factor authentication capabilities, particularly role-based access controls, timeouts, all of that sort of stuff. That's a part of something called the HIPAA minimum necessary standard, which means that if you have an employee in your practice that does not need access to all of your patients' information, they shouldn't have access to all of your patients' information, okay? So your EMR should have those capabilities to make sure that you can lock people out of certain aspects of the platform and records. That role-based access is really important in order to maintain proper confidentiality under the minimum necessary standard. And the next thing, thinking through cybersecurity insurance, making sure your EMR has that. We also get a lot of questions though about you and kind of like what you should be thinking about when it comes to cyber insurance within your own practice. And there's a few things that I'll say about this. Is cybersecurity insurance, for those of you that are super unfamiliar with this, is its own thing. And generally speaking, if you have a general liability insurance policy, cyber risk will be specifically excluded from that policy. So again, I talk with a lot of practices and they are assuming that their general liability policy covers cyber risk. And 99% of the time, it does not. And so that's where I would encourage you to begin, is get an understanding of what is actually covered in your general liability policy. Cyber insurance is focused specifically on if you have a cyber breach or an incident to cover the damages or any issues or legal problems, all of that sort of stuff. But frequently, in order for cyber insurance to actually cover you, it takes it under advisement that you are already HIPAA compliant, right? So frequently, as an example, it's very rare to ever find a cyber insurance policy that will pay for a HIPAA fine, right? Just like my car insurance doesn't cover me if I get a speeding ticket because I was breaking the law. If you are audited by the government and you're fined for a HIPAA issue, insurance generally isn't going to cover that because you were found to have been in violation of the law. And so understand that, like, that doesn't mean if you have a breach that it's going to be a problem. It goes back to you being able to prove that you were satisfying these requirements, right? I say this often, but it's not about being bulletproof. It's about making sure that you have proof that you're doing these things, right? That's how you protect yourself. Now, the other thing that I see happen sometimes is somebody will fill out a cyber insurance application, and they'll just do like, yes, 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 yes. We have all this all the way down the line. Understand, if you have an issue, the insurance company probably doesn't want to pay out hundreds of thousands of dollars following a cyber incident. So they're going to review your initial application. And if they identify that you misrepresented yourself, it can create problems for you down the line. So it's something you want to really look at. It's a binding representation of your risk posture. You want to always fill those out as absolutely honestly as you can. We already talked about documenting everything. And in general, this is meant to be supplemental, right? This should be an extra protection so that if all else fails, you have something in place. But there are plenty of other things you should be considering prior to engaging a cyber insurance carrier leading up to that. Okay. We're gonna kind of wrap things up here, I think, with a few concluding thoughts, and then we'll give maybe just 1 or 2 minutes. Me and Lauren had one or two other things we wanted to share, and then we'll go to some questions. Key takeaways here: to mitigate human error, you want to always be training your employees and having the right policies and procedures in place. But also, fourth time I'm mentioning it, if you're keeping track, complete your HIPAA risk assessment. There was a lot of you that said that you have not done that, or have not known how to do it, or are not familiar with it. That should be one of the first things that you look at. But then as you're going back to your practice today, think through, like, if you took a snapshot of your practice, just ask your employees, not because you're trying to bust them on anything, ask them if they're ever using like ChatGPT or other AI tools, and make sure that you have procedures in place to ensure that it's being used wisely and compliantly. And lastly, vet these tools that you're using. Double check for a BAA. Use that nice checklist that Lauren gave for those technical requirements to make sure you're doing everything right. And so in a second here, we're going to cover some questions with the time that we have remaining. For those of you that are interested in this, Compliancy Group and OptiMantra both have free trials available of our platforms. I'll say on the Compliancy Group side, you can actually complete a HIPAA risk assessment instead of our free trial. It's super easy. You could check that out. You could also look at our policies. You can do some test trainings, completely free, no credit card, no obligations. You could scan that QR code, or I'll send this link here in the chat if you would like to check that out. Lauren, anything you wanted to mention about the free trial with OptiMantra?
Yeah, you'll have access to everything included in our base subscription, our 2-week free trial. So you'll be able to test out that secure patient portal and see if that works for your liking, our secure emailing. Take a look at the telehealth platform. All of our templated policies, our forms and everything that you're able to use charting wise, that's all vetted by people on our end and it's okay to use. So instead of generating things in ChatGPT, I'd recommend you check out our thousands of templates that we provide in OptiMantra.
Awesome. Yeah. It's free to check it out, everybody. So you can scan the QR code like with your phone, or you can click the links here that we're sending in the chat if you'd like to check out a free trial of either platform. With that said, I'm going to go through some of the questions here. And I'm seeing some great engagement from everybody in the chat. Thank you for those of you that are actually chiming in on a couple of things. I'm just prepping in advance. I'm not going to be able to get to everything that is in the chat here. I will be going through a bunch of the stuff that we have in the Q&A section though. So if you sent your question in the chat and didn't send it in the Q&A, go ahead and send it there now, and we're going to start going through them. We have like 10, 15 minutes left here before we'll need to wrap it up. So we'll see how many questions we can get through. So this will be one for me, but I can imagine that a lot of you will have this question as well. So Nancy, you asked, is Google Workspace with a BAA okay to email patients from? So Google Workspace with a BAA, the answer is technically yes and no. Google Workspace with a BAA will be compliant in the sense of data storage and the services that you're using. In order for you to actually be back and forth emailing with your patients, those communications need to also be encrypted. So usually our customers, once their BAA is in place with their Gmail account, let's say, they'll also use an email encryption module, something like Pawbox or Luxi or company. And I know that OptiMantra has this built into the system as well. Is that correct, Lauren?
For which part?
For patient emailing from the
Mhm.
EMR?
Yep.
Yes. So OptiMantra, if you're using their system, also great ways for secure and compliant emailing. But for data storage in your email, you do need that BAA with Google Workspace. Okay. There was another question that I saw. Let me see.
What about, Liam? I was going through the questions when you had asked me one. The best way to review state guidelines, because we talked about that a lot.
State guidelines is going to vary. My suggestions on when it comes to state guidelines is it'll depend on the state that you're in, first of all, because there's actually not a lot of states that have healthcare privacy requirements that supersede those of HIPAA. There's also not a lot of states that supersede the data security requirements of HIPAA. There's only a small handful of them. So first, like Texas, New York, California, those states tend to have some complexity to them. In general, though, because things like the HIPAA regs are federal requirements, I encourage our customers to start there and to think about what do we need to be satisfying at the federal level, because that can often be what's most heavily enforced. And then if you need to seek legal advice for state level guidance, that might be something where you could consult with a local regulatory attorney or a consultant that you trust.
Here's one I could take. Can you chat with ChatGPT about clients as long as there is no patient personal information? Technically, if you're not putting any PHI or any information into AI that would let them identify the patient, you can. I would say it's still a major risk, and I would recommend that you don't.
Good recommendation.
You can, but I wouldn't.
Yes. So another question, I'm seeing a bunch of BAA questions. We'll try to go through a few of these just to find some different use cases. So our company has a BAA with Microsoft and Copilot. Does that still mean that you cannot use PHI for case consultations? Do you have any thoughts on that, Lauren?
I gotta stop reading the questions while you're saying that.
So I would say Dana, assuming that you're using Copilot, like Microsoft's AI solution, and you have a BAA in place with them, I would review the terms and the provisions of that BAA to see if Copilot is actually covered under the Microsoft BAA provisions. Anytime that you sign a BAA with a company, there are frequently covered components of the service that the BAA is governing. There might be other things that they don't. So you might want to look into Copilot's comfortability as far as that's concerned. I am not fully familiar as to whether or not Copilot, and I'll actually look it up right now to see.
And as you're doing that, I'm seeing a lot of questions about will we get recordings of the session? You will. It typically takes a few hours for it to record, but within 24 hours, you'll get an email that has the slides and the session recording.
Yeah. So it looks like Microsoft advertises that Copilot is covered by their HIPAA BAA, understanding that you would be using it within Microsoft's secure and compliant portfolio of services. That could be okay. I would want to look into it a little bit more before I make any firm suggestions on that, though.
If you're a single provider practice, Liam, is there still a need to have policies and procedures?
Yes, absolutely. So even if you're the only provider, you need to realize that the government would ask you for those policies and procedures in the event of an audit, right? So even though you're the only one, there still needs to be clear documentation how you operate as a practice that highlights the ways that you're understanding and applying those procedures within your business. If that's not in place, again, how would you prove to the government what you're doing if they were asking you for those documents, right? Because they would ask. So much of what they ask for is policy related. Any other ones, Lauren?
Yes, all of a sudden I'm not seeing myself. Are you able to see me still?
I can still see you.
Okay.
Yeah.
I've gotten a few. What is a good free HIPAA risk assessment that people can use?
Well, you could go ahead and scan that QR code. You can get access to our free HIPAA risk assessment for 2 weeks, and you could feel free to check that out if you wanted to actually just go through the exercise of doing it. There is a free resource available through the government as well. It's basically like a spreadsheet template and it can have some challenging technical language in it because it's through healthit.gov. But I'll send it here in the chat. This is what the government provides as their resource for a security risk assessment, and you could check that out.
How often are BAAs required to be updated?
Generally speaking, you don't need to update a BAA once it's in place, unless your contractual relationship with that vendor changes. So like in an example like what we were talking about before, if I've purchased a specific stack of services, let's say from a vendor, and then I expand my contract with them into a bunch of other areas, usually we would recommend signing a new BAA with them to just make sure that you're freshly covering those new provisions of your contract. I saw some dialogue in the chat before around, well, like we have a contract, what's the difference between a contract and a BAA? They are different. So you shouldn't ever assume that your contract includes the provisions that would be in a BAA. They are generally speaking separate documents that should be tracked uniquely, right? Because the provisions of your BAA last for as long as your contract is active with the vendor, right? But you would not need to report on your contract if you were ever audited or had a breach. You need to report on your BAA, right? So I recommend treating them separately and looking at them separately.
Seeing some follow-up here to that ChatGPT question. So what if the information provided related to a patient grievance in ChatGPT is generic and does not identify any specific individuals? It's okay. I don't know that you're going to get the greatest response from ChatGPT, like we talked about earlier, even with Liam's example of not knowing who the current president is. I don't know that it's where I would go to field patient grievances, but again, as long as you're not putting any PHI directly into AI, it's okay. We just don't recommend it because there's some potential slip-ups and areas for concern. Liam, are there free resources that people can use to help become more knowledgeable on HIPAA requirements?
Yeah, I mean, listen, we have tons of resources even available on our website. Lots and lots of free stuff. If you check out our website as it concerns HIPAA requirements, we have a free HIPAA checklist. We have a blog. We do these webinars pretty regularly, so I'd encourage you to check those out. Another great resource is HIPAAjournal.com. They also have a lot of great content and insights as far as the HIPAA rules are concerned, as well as like a lot of current events that can be helpful to keep up on. So all of the above, yeah. Obviously, you also have the federal government, which is hhs.gov, but sometimes the information in there could be a little bit difficult to parse through if you're just getting started with us.
And we have some articles on our blog too that outline HIPAA requirements for an EMR and HIPAA requirements for telehealth. So just typing in HIPAA into our blog search bar should get you some good resources. Does Compliancy Group help with SOC 2? And maybe a little brief summary of what SOC 2 entails, Liam.
Yeah. So we do cover SOC 2. It's part of our more advanced risk assessment tool set. So it would not be something that you see if you're doing a free trial with us. I actually saw a question in the chat earlier too about if a covered entity has gone through a SOC 2 audit, do they still need to do a HIPAA risk assessment? For those of you that don't know, SOC 2 is a very advanced cybersecurity audit process and certification. Very popular, especially for healthcare software companies and vendors. They are different though. So if you are SOC 2 compliant, it doesn't necessarily mean that you're HIPAA compliant. If you're HIPAA compliant, it doesn't mean that you're SOC 2 compliant. There are going to be tons of provisions under HIPAA, especially on the privacy and breach notification side, that are just completely not governed under something like SOC 2. SOC 2 is quite often very data security focused and driven. It will be heavier from a technical perspective than HIPAA, but a little bit lighter on a lot of the administrative stuff. So think of them as different things. You can use us for both though, but I would not think I've done a SOC 2 audit, therefore I'm HIPAA compliant. That's not the case.
I think you'll like this one. If people sign up with CG software, do you complete the risk assessment for them?
We don't do it for you, but we make it really, really easy. You essentially activate a questionnaire inside of the system. And then within the questionnaire, it's like plain English, yes, no questions. We tell you if you don't know the answer no, right? Because it means you probably wouldn't be able to show documentation in an audit for that. From there, the system actually generates guidance for you. It provides you with tasks. It provides you with training, with policy templates, with all the stuff that you might need to actually fix the gaps from that risk assessment. So our goal is to make it really software driven. That way you can go through those steps and kind of set up your compliance program as you're going through it. So again, if you have an interest in that, definitely please reach out to us.
Are all HIPAA risk assessments the same?
No. Really good question. I love that question.
Mm-hmm.
So even that tool that I sent before that's available through the government, that's going to apply to most of you. So assuming that we have mostly small to mid-sized groups here on the call, that general SRA template is designed for what the government calls small healthcare organizations. What is a small healthcare organization? They literally don't say. They don't say. But there's a few pieces of guidance that they give, meaning like lack of internal resources. You don't have a dedicated IT team or an IT company internally. Our general rule of thumb is that if you're less than 500 employees, the standard HIPAA SRA is probably fine. As you're north of that is when you might want to consider a more advanced version of that assessment. But for most of you that are on this call, the basic one should be okay.
Probably have time for one or two more. Are there any tools that you know of, Liam, or any best practices for ensuring that a business associate that you're working with is compliant with the HIPAA requirements, or is it just that BAA?
Yeah. So, well, part of a HIPAA risk assessment is that you actually build an inventory of these cloud applications and then document that those controls are in place along with a BAA. That's probably the easiest way to go. You could do that on a spreadsheet if you're doing it yourself. In a system like ours, it would be something that we do with you digitally.
Great. And does the Guard have NIST CSF in place?
We sure do. That's part of our advanced program library. For those of you that are not super savvy, I saw somebody mention that HIPAA requires that NIST CSF be in place. That's not fully accurate. So NIST CSF is NIST cybersecurity framework. The HIPAA security rule is actually based off of something called NIST 863 or 53, one of those. NIST CSF is going to have more advanced standards than a traditional HIPAA security program would, but we do cross-map to it inside of our system for those of you that are looking for a more advanced assessment module. And with that, folks, I actually, we are now running out of time with a minute left, and believe it or not, I have another webinar with a partner 1 minute from now that I'm going to need to jump on as well. So we so appreciate all of the questions and the engagement today, folks. I apologize in advance for those of you that we were not able to get to your questions. Please just reach out to us. We'd love to chat with you. But with all that said, we hope that this was a helpful session for all of you today. We really appreciate your time, and we will be picking this up. Keep an eye out for our notifications. Sign up for those free trials. You can reach out to Compliancy Group or OptiMantra for anything else.
Thanks, everyone.
Cheers all. Thanks.